The case management conference is being held by way of teleconference. Any orders or directions made after or during the course of this hearing will be issued by the registry in Dubai on the judicial officer's instructions. We are here for a hearing in the matter of, we're here for a CMC in the matter of CFI-009 before Judicial Officer Nasser al-Nasser. The claimant is represented by Al-Sharif Advocates and Legal Consultants. Lead counsel is George Seferet. The defendant is represented by Hamdan al-Shamsi Lawyers and Legal Consultants. Lead counsel is Hamdan al-Shamsi.
Good morning and welcome.
Good morning.
The claimant may start, please.
Yes. Let me summarize our two claims. We are representing Mousa having two claims against the defendant, which is based on two sub contracts. The claim number one is for an amount of 2.8 million and the return of an original guarantee check in the amount of 510,000 dirhams. We are arguing that we have done all the works, and that's why we are claiming the missing payments as well as the return of the guarantee check. And the defendant in this case is of the opinion that the claimant has not fulfilled all the work, that the work were not final, that there were 40 works, and for that reason the claim has no value, and the defendant tries to prove that with some documents which he has produced himself. So in our opinion, that does not stand as an evidence. And additionally, the defendant says that the calculations made are wrong, and that to the contrary, the claimant is owing the defendant an amount of around 476,000 dirhams. And this also has, in our opinion, not been proven. This is just a statement. And the second claim is for an amount of around 7 million dirham and a guarantee check in the amount of 1.3 million. The reason for that is the same. It's a subcontract agreement. The claimant has fulfilled the work, and that's why we are claiming that. And the defendant says there has been a settlement agreement that was executed between the claimant and the defendant in relation to this subcontract, and that the claimant in this settlement agreement waived all further claims and rights regarding to this subcontract, and that for that reason the claim should be dismissed. And the claimant's position on this is that this settlement agreement was made under duress. The reason for that is that performance guarantee check was put into the bank. It bounced. It was then that the defendant said to the claimant, if you're not going to sign this settlement agreement, the one who signed this check, which was the son of the CEO of the claimant, we will criminally pursue him and put him into jail, and this is the reason why this settlement agreement was signed. So the claimant is of the opinion that this settlement agreement has been made under duress, and for that reason is null and void. Then there is an issue on the jurisdiction and the governing law. The claimant is of the opinion, since in both the subcontract agreements, which are related to Claim 1 and Claim 2, it is clearly mentioned that the DIFC has jurisdiction, and that the UAE federal laws shall apply, and the defendant is of the opinion that this is not the case for Claim 2, because he refers in this case to the settlement agreement. That's it from my side for the moment.
Thank you. Any response from the defendant?
Your Honor, I thank my learned friend for his explanation. We disagree with some of the statements he's said. However, we'll focus on the CMC for at this stage. As a brief, Claim 1, the claimant is claiming around 2.8 million dirhams for a project called Manazil al-Khor. We do agree that DIFC, the parties have agreed and submitted to DIFC jurisdiction, DIFC court's jurisdiction, rather. As for Claim 2, the claimant is claiming an amount of 7,061,000 circa, and this is in relation to a separate project, completely different. Actually, the project was complete, and the matter was settled, and the parties have submitted to the jurisdiction of Dubai courts. We reject the claimant's submission that this was done under coercion. This was signed, an agreement signed by the claimant. He had legal representation. He had lawyers involved during that time. We state that these two cases, and we've stated since the beginning, unfortunately the claimant has rejected and tried to make, we believe that they've tried to make the cases one, when really the two cases are, they are two different projects. The witnesses will all be different. The facts and documents will all be different. Therefore, we state that those cases have to be disposed of separately. There are a list of, Your Honor, there's a, in respect of the CMC, there's a list of issues we would have liked to have agreed on, but unfortunately we have not agreed on. And there's a timetable that we have not agreed on. And there's a slight issue with the experts that we have not agreed on with the claimant. We find that the claimant could have made things easier by separating the two claims. They are separate by their nature. And the fact is that we have a jurisdictional issue to deal with in one of the claims, which is Claim 2. I'll just mention the project number to make ease of reference. That is the Sparkle Tower. So with that, there's a jurisdictional issue. The reason being is because the parties have submitted to the jurisdiction of Dubai courts. Your Honor, I leave the court to direct us how we wish to proceed, but I would like to talk about the timetable, list of issues, and what we haven't agreed in the experts, and the order we're seeking for the CMC.
In relation to the jurisdiction, why there is no application to contest the jurisdiction?
So, Your Honor, that is because a settlement, I'll take you to the documents, which is one, sorry, Your Honor, bear with me, sorry. So this is the case management, how is it? Sorry, Your Honor, I just have it on paper, but only. Yeah, the settlement. Oh, sorry, we didn't put it. Your Honor, we have not submitted the settlement agreement, unfortunately. However, it clearly refers to Dubai courts as having jurisdiction. Therefore, I submit that this is we have a jurisdictional issue first to deal with. So, and Your Honor, I think I might have missed what you said. You mentioned that why haven't we done an application in relation to jurisdiction? Because the claimant have brought forward two claims and put them as one. Under the DIFC the application form, for the first claim, we do agree that the DIFC has jurisdiction. For the second claim, we contest and we say that the jurisdiction is of Dubai courts, and the issue is in the DIFC, the response form has only two options. And whilst the first claim we agree with the jurisdiction of the DIFC court, the second one we don't. So we had a slight issue with with that. We have contacted the registrar, we have contacted the claimant, and we've clarified our position. Yes. So one of the things we want to obviously decide on as a preliminary issue is jurisdiction, Your Honor.
May I ask the claimant how does the two contracts are related to be both in one single claim?
Sorry, Your Honor.
This is a question for the claimant.
Sorry.
How are the two contracts related to be bought on a single claim?
Yeah, we are of the opinion that this is the nature of any case. If you have two claims against the same defendant, that they can be combined in one case. Both of the cases are based on subcontract agreements. And yes, of course, the contents of these two agreements and the works are different, but at the end of the day, the nature of the claims are the same. It is a claim for payment of works done and the return of payment guarantees checks. And this is exactly the same in both of the claims based on the subcontract agreements, which both say in the contract the parties are agreeing to the jurisdiction of the DIFC, and for that reason we are of the opinion that this can be done in one claim, and that for both of these claims the DIFC does have jurisdiction.
But each contract is in relation to a different matter. Although it's the same defendant, the same nature, but each contract is different than the other.
That is, I absolutely
it's in relation
agree,
to
but this is the nature. Otherwise, you would never, Your Honor, be able to combine two cases if they are based on two different contracts, and that's why we are of the opinion that the nature of these two claims are the same.
Yeah, the nature is the same, but there are two different projects, two different the same parties, but the same subcontractors, but two different, I believe, main contractors. The terms, I'm not sure about the terms, whether they're similar or not. In one case, there is a settlement. I didn't view the settlement agreement, so I can't decide on the settlement agreement.
Yes.
But as a thought, it's different. So the approach will be different in the two contracts. So I have to view the documents first to decide whether they should be in two different cases,
Yes,
or it should remain in the same CFI number.
Yes.
But in terms of the CMC, I'll advise the defendant to file an application to separate the claim, attaching its supporting documents. The court then will decide.
Your Honor, we agree with that, and we will make an application due course. I just want to point out, Your Honor, that the claimant has failed to make full and frank disclosure in relation to the settlement agreement. This would have been much easier if, when the claimant approached the courts, he mentioned that Claim 2 had a settlement agreement signed between the parties. That was not brought forward. That was not mentioned, actually.
Now, I don't think also we can proceed with the CMC and issue a CMC order when there is an issue pending.
Right, Your Honor.
It doesn't make sense to issue a CMC order in relation to a case where there will be an application to separate the merits of the claim, or to separate the agreement within this case.
Your Honor, then I believe it is prudent for us to then make an application to separate the cases, and in one of them to apply, for the registrar to separate the cases, and in one of them to put a jurisdictional challenge in, which is the second claim, and that would make the courts work much more easier, efficient, sir.
Yeah, I believe so. Then I'll adjourn the CMC hearing. The defendant has to file an application supported by evidence, and then the registry or the courts will decide.
Your Honor, we'll do so. We will just mention that we want to also put a jurisdictional challenge along with the second claim concurrently or in parallel at least.
Yes, yes, please, and then the courts will decide, as I mentioned. If the court saw that it shall remain in the same case, you'll be able, I think, to file an application to contest the jurisdiction in a certain matter of this claim.
Sure, Your Honor. We'll do so as soon as possible.
Thank you. Anything from the claimant side?
No. Thank you, Your Honor. At the moment, fine. We will wait then for the application and the decision of the court.
Thank you.
Thank you, Your Honor.
When will the defendant file the application? So
please, the courts. If Your Honor would allow us just to write to the courts in respect of that, we believe that by the 14th of October we would have submitted everything, Your Honor.
Okay. Okay, by 14th of October.
Yes, sir. Please, the court, sir.
Thank you.
Thank you, Russ.